Hello, everyone, and welcome to the Legal Queen live show. I am your host, Tracy Maloney, aka the Legal Queen. I am also a practicing family law solicitor and have been now for over 20 years. I've helped thousands of people with their divorce, their finances, their child custody matters, and lots more. So if you think that you could benefit from my help, then feel free to join me on my Discord channel. Pop your hand up and I will welcome you onto the stage where you can ask me a question. Cowie, there we go. How can I help?
Hello.
Hi.
Okay. I think I should start off by saying, so me and my husband are in the process of a divorce, and
Yes.
we have a we have a surrogate child, but I
Yes.
have no biological relation to that child, and he's on the birth certificate, and I fear that our divorce is going to affect my my ability to have parental rights to that child.
Okay. I'm just going to ask you to tell me the bit about the birth certificate again, Cowie, because you just dropped out there. Did you say you are on the birth certificate or you aren't?
I am not. We were
Okay.
getting to the process of me going onto the birth certificate, but
I'm with you.
the divorce has like stopped it in a way.
Okay. No, that I understand. So how old is the child first of all?
The child is 5 months old.
Okay. And um, when you say you were in the process of going on the birth certificate, was that so that you could have parental responsibility?
Yes.
Yeah. And can I ask, was there a reason that you weren't put on the birth certificate sooner when the child was born?
Because I'm not the other biological parent, so
But you
he wanted
mentioned,
to
I'm just sorry to interrupt you, but you mentioned that you're married.
yeah.
Okay. All right, that's fine. What you want to do then, if you suspect that the divorce, and I think what you mean is the separation, is going to have a negative impact on you having a relationship, then you need to be making an application to the court, okay? And you do that by using the C100 form, and you can do that now. And on the front of that form, it will say, do you need permission to make the application? And you tick, yes, I do. All right. And you'll then give a very short narrative of how you are a constant in the child's life and have been for the last 5 months. But for the reason specific to your family, you haven't been placed on the birth certificate. Okay. So you are making an application for what's called a child arrangements order. Now, by virtue of getting that application, Cowie, you will automatically be given parental responsibility if the court feel that's in the child's interests. So it won't matter then that you are not on the birth certificate, because at the moment you're going to need your spouse's consent and agreement to go on the birth certificate. And based on what you've told me, you might struggle to do that. So, but if you make the C100, you're not going to need your ex's consent. Do you see?
Yeah.
Okay. Does that help, or was there something else?
So obviously I asked about the parental
Yes.
rights thing,
Yeah.
but I have a additional question about
Sure.
if the divorce goes through before uh I get the rights to the parental rights,
Yeah.
like how would that look? Because obviously we'd have to settle other stuff during the divorce, uh like finances and all that. But obviously if I don't have parental rights, how are we going to settle that?
Yeah. So this is a really good question, and it's so common when couples are getting divorced. A lot of times, Cowie, we have to pause the financials until we sort out the children's matters. Okay, so all I can say to you is if you know today that your husband is not going to agree to you having parental responsibility, or more importantly, not going to agree to you having a relationship with your baby, then make that application now. Okay, the divorce process itself takes 26 weeks, which is 6 months. If you make your C100 application now, you're going to get before the judge in probably 3. So, and the fact that you've got an application before the court, regardless of the fact it might not be finished, will be taken into account. So you will have your children's application running alongside the divorce. And your children's application will be dealt with. And then if you can't agree on finances because we don't know where the baby's going to live or how much contact you're going to have with the baby, then you just press the pause button on that. And you just have to, sometimes there's a stalemate for the finances until such times as we finish the children's matters. So don't panic about that. All I would say is get your application in good time.
Yeah. Okay, thank you.
Pleasure. All right then. All the best. Bye-bye. It's difficult, isn't it, when people are going through divorce and obviously they're not, focused on the divorce and the finances, even though that needs to be dealt with. They're really interested in having the children and having a relationship with the children or even residence of the children. So I totally get where Cowie Panda is coming from. And there's so many other people, I'm sure, who can resonate with that fear, with that, what is it that I do first? What if one thing happens? Is that going to have an impact on the other? Children's matters are very much centered around what's in the best interest of the children. So if you have been in your child's life, regardless of whether you're on the birth certificate or not, the court's going to want that to continue. This was a family unit once upon a time. Captain, let me come to you. Take you off mute. Hello again.
Hello. I have 2 children, which are neurodivergent, ADHD, and autism, age 6 and 8. My kid's dad keeps swapping and changing when he wants them. What can I do so he has it legally set days and can't keep changing all the time?
Okay, so we're talking about a child arrangements order, which will be written down. So it's an order that will have a framework of contact, basically saying that the children live with one of the parents and have contact with the other parent on these days at that time. And it can help where we have inconsistency because we then have sort of a timetable, if you like, to follow. And if the parents feel that helps, and if the other parent misses a contact, then we don't, we just say, fine, you've missed the contact. Now you have to wait till next week before the next contact happens. It can help some families, not all the time. In order to get that contact order, you have to make an application to the court, and you do that by using the C100 form.
I have a live with order and a contact order in place to the court. However, the father isn't doing what the contact order says. What can I do?
Well, it depends how he's breaching it. I mean, we can't force a parent to have contact. So if the father isn't doing what it says in the order, i.e. he's not turning up to collect the children, there isn't too much we can do in that instance. But it might not be that. It might be that, I don't know, father isn't, when the children are on his time, maybe he's not taking them to a certain club. Or maybe he's not, taking them to see the grandparents, which has been ordered. So it's difficult to answer that without knowing more context. If we have a direct breach of a contact order, then we can take it back to court to enforce the order. But as I say, if the breach is that he's just not turning up, then there's nothing we can do there.
Okay. That's all the questions I've got at the minute, Tracy, but I thought as soon as we don't have any hands up,
yes.
What can you expect at a first appointment for a child arrangements order?
So that's a really good question. At a first appointment, the court's going to want the applicant to set out their case. So what seems to be the issue here? What does the applicant asking for? Are they asking for a live with order? Are they asking for a change of residence? Are they simply seeking some contact? So let's understand what it is the applicant wants. And then once the court's clear about that, they're going to turn to the respondent and say, why are you objecting to that? What are your concerns? What are your reasons? And that way, the court is very clear about what the issues are. And then typically, depending on what the issues are, but typically CAFCAS will then be ordered to intervene. And CAFCAS is seen to be that neutral third party that will speak to mum, speak to dad, speak to the children if they're of an appropriate age, and report back to the court with their recommendations. So, this is what we suggest the court should order based on our, conversations with everybody involved. So that is sort of the first appointment. No order is made really unless the parents agree. The type of order that's made will be that CAFCAS will get involved. If one of the parents is maybe alleging that the other one has some addiction issues, the court might suggest that we have some hair strand drug testing or hair strand alcohol testing. But unless the parents can agree, and chances are they don't at the first appointment, there'll be no order as to contact made. Unless there's an agreement reached for supervised contact or something like that. So it's more housekeeping, the first appointment. I'm going to come to Damien. You're next. How can I help?
Hello, my love. Struggling with an order at the moment. Currently, recently just got a new order. Well, it's in process of being handed back to the judge. I had court yesterday. On that order, there was something that I was meant to receive, information that I was meant to receive by the end of the day yesterday from the mother. I've now got a lives with order, so my twins live with me. But the information hasn't been given to me. My barrister has turned around and said, if she doesn't do it, you just got to try and reinforce it. So I've done that via a parenting app. But apart from that, I don't even know where I'm meant to go because it's on the order. It's just we just haven't got it in paper form yet.
Are you able to share with me, Damien, what it is that you had to receive yesterday?
Yeah, so it was just contact details for my children for when they're in the mother's care. If any things arise, any situation arises. But that was meant to be handed to me after court. That's what the other parent, well, the mother, has stated. Yep, no, we can sort that within an hour. And we've had nothing at all.
And when is mum's first scheduled contact due for?
Well, she had her first contact on Tuesday, but obviously with everything that's changed on Tuesday, it is her next scheduled is Friday.
Okay. And is the order specific, Damien, in that you must have this information before you can release the children for contact? Is it conditional upon her giving you the address?
Yeah. So
Okay.
I haven't got the paper form yet because it obviously was only in court yesterday.
Yes.
But,
yeah.
Yes, from memory, it is. You're not allowed. I'm not allowed to release them into her care until we've got that information.
Yeah.
Because of X, Y, and Z. So.
Absolutely. There's concerns there. That's why you're being mum's been told to give you her whereabouts. Well, then, unfortunately, until mum provides you with those details, you're not able to release the children for contact, which is a shame because, we don't want to have to break the children's routine. And I'm sure they're looking forward to seeing mum. So, but you are caught between a rock and a hard place there, Damien. You're going to have to abide by the order. So are you able to contact mum? There's no non-molestation or restraining orders or anything?
No. We use the parenting app, the app Close app.
Okay.
Constantly. But obviously, I messaged yesterday asking to receive it, and I should have received it by now. And I gave her till 12 o'clock today, for instance, just to come up with the information, just in case whatever she's trying to give a bit of leave room. And I haven't received anything at all.
Yeah.
So yeah, I don't know where to come at from that. I know that it is a fresh. We literally stepped out of court yesterday at 5 o'clock with a brand new order. Everything's all new, as well, because it was the final order, final case yesterday. So I know it's all new, but this information should have been handed to me for
Yeah.
just safeguarding reasons.
Yeah, and I think that you've done all you can by the sounds of it. Mom was present at court, so she also understood the order that was made, despite you not having received that sealed copy yet from the court. You
Well,
have
Mum was the one
also
who suggested it.
okay.
She said that I could get it to you to the end by the end of the day.
Great. So you have also emailed her, or sorry, WhatsApped her through the parenting app to say, look, I can't release the children to you on Friday until I've got the address. There isn't too much more you can do, really. And it's unfortunate, but until she gives you that address, it may be that she misses contact a couple of times, you know, but if that's what the court wants and that's what Mom's agreed to, then that's what you need to stick to.
Right. Okay. I have got another question for you, my love.
Yeah, sure, yeah.
So obviously, there's a 7-day period, and the children have to come back to me. So Mum's only allowed to have the maximum of 7 days. Now, with going abroad, didn't fully understand this in court yesterday, because the judge has turned. Mum's got restrictions on taking the boys aboard, my children aboard.
Yeah.
So it is, I need to see boarding passes. She has to go with certain people, X, Y, and Z. So, and if it's not all in check, then they don't go. But from my understanding, from what the judge was saying, that because the judge has ordered, yes, X, Y, and Z's got to be done before they go on holiday. Mum doesn't need my approval.
Right. So what's your question? Sorry.
Is Mum able to take the children away, my children away on a holiday within her contact time, without my permission?
Well, that's going to come down to what the order says. I'm a little bit confused because Judge has said to you that she can have them for a holiday, but that she has to provide you with all of the travel documents before she goes. So
Yeah, that's correct. Yeah.
as long as she provides you with the travel documents, then you would have to make them available for that holiday. So I suppose in that regard, she doesn't need your permission. But if she doesn't provide you with the travel docs, then you don't have to allow them to go. But I would wait until I saw that order specifically to see exactly what the wording is.
Right. Okay.
That is a holiday likely to happen soon, Damien, or do you think we get the order in before then?
Oh well, no. The order's being sent to the judge on Friday, and so we should get it next week.
Oh, good. And Mum's not planning a holiday.
Wednesday.
Okay, that's perfect. Brilliant. Well, I hope that was helpful. Captain, you have another question for me?
I do. I've got two, and I've got one of them's from iced tea.
Okay.
So it says, mediation signed us off in February 2025. Dad agreed to see our daughter, 5 years old, once a month and call twice, which are fluid. If he breaks what he has agreed, will we need to go back to mediation or make an application to court? I do communicate with him when he breaks what we agreed. However, he always has a personal excuse. This is typical of his behaviour. What is the rule of thumb for when to make another application to mediation, as he has only agreed once a month, so the distance between when he sees her can be greater?
Yeah, so Ice-T is still in the lounge, and thank you, Ice-T, for letting Captain know of your question. It comes back to what I said to an earlier caller, where you can't force a parent to have contact. So you've attended mediation, you've agreed a contact schedule, and sadly, Dad isn't sticking to it. I would suggest if you and Dad are in agreement, go back to mediation. Definitely don't make a court application, because the court application is asking Dad to stick to contact, essentially, and asking him to adhere to the agreement that was made at mediation. And that is essentially forcing him to have contact, and we can't do that. If he doesn't want to have regular contact, as sad as it is, we can't make him. So I would suggest go back to mediation, but maybe use mediation the second time round to illustrate to him or to describe to him just how impactful his lack of consistency is on the child. You know, to use that as an opportunity and have the mediator help explain to him this isn't in your child's interests. And whilst you may always have a good reason to skip contact, miss contact, or what have you, as a parent, you've kind of got to step up to the plate. You do have to, you know, be there for your kids no matter what. So my suggestion for iced tea would be go back to mediation if dad's in agreement.
So she just put a follow-up to this saying the mediator did that last time, which was a shock to the system for him, I think.
Yeah. And it might be that it's reinforced, and the mediator could then say, and look, if it continues, you're at risk of iced tea, and I appreciate that's not your real name, iced tea saying, right, this is so impactful, I'm just not going to allow contact to continue anymore, you know, and have the mediator maybe spell that out to him. But I mean, what may then happen if iced tea stops contact because the inconsistency is so disruptive and the child's getting disappointed all of the time, is that dad may then make an application to the court. And that's fine. You know, we would welcome that. Iced tea would simply let the judge know the reason why she stopped contact.
Yeah. And then last question from me today, Tracy.
Yeah.
Not sure what to expect when the application for a non-molestation order gets heard in court. Can you advise, please? Just wanting to understand what the process is in court looks like, what to expect, as I'm extremely anxious about it. And also this person is autistic as well, if that helps with your answer.
Okay. So typically a non-molestation order is made, or application, sorry, is made in one of two ways. You can make it on notice, which means that the other person is served with the application and knows of the court date and will attend with you, or you make your application ex parte. And that means that you are not letting the other side know because you're afraid that you're applying for the non-molestation order. So essentially, let's take the ex parte scenario. You're going to attend court within a couple of days of you making your application, and you're going to be given your non-molestation order because the court want to protect you until they can have time to do further investigation. So you have your non-molestation order, and then the court will order a return date. And that return date must be served on your opponent, the respondent. And then the respondent's invited to attend court. It will be his or her first time, the applicant's second time, and given an opportunity to defend the non-molestation order. If they don't turn up, typically the court will allow the non-molestation order to continue for about 12 months, okay? If it's the second scenario where it's on notice, so the other person has been given notice of the hearing date, then the court will do what they do in the second hearing on the first hearing. So they'll just say, right, we've got a non-molestation order application, today. They will speak to the respondent about, you know, their version of events and make the decision. If they can't make the decision that day because there's insufficient evidence, they may set it down for a final hearing or a trial day, so that you both give more formal evidence. And what I mean by that is you're cross-examined, you're given evidence in chief, you're, you know, bringing evidence along to support your allegations, etc., medical evidence, police reports, that kind of thing. So they're fairly straightforward. They don't have more than 2 or 3 hearings. If the respondent, your opponent, never turns up, it might be given to you at the first or even the second hearing, ongoing. And generally they last about 12 months.
Okay, thanks, Tracy. And I've just had a poke from Mark because he sent me a question and I forgot to ask it.
Yeah.
What can a parent do if a child is in hospital or having an operation, but the other parent fails to inform the parent who doesn't know?
Yeah, I mean, that's really sad. That's not a legal dispute, really. That's more of a co-parenting issue. If both parents have parental responsibility, then we need to be sharing the big decisions, like, you know, the big picture stuff, which is your medical, your religion, and your education questions or decisions with each other. You need to be sharing those. So out of nothing more than courtesy, if your child is being taken to the hospital or needs to be operated on, you should be letting the other parent know, okay? Unless there is an order that prevents you from doing so, or unless there is some, other circumstance. But you should be letting them know. If, as the parent who hasn't been let know, the question is, what can I do about that? You can get an order from the court that says, with all decisions around medical, religion, education, you will let the other parent know. But of course, if the other parent doesn't do that, you have to keep returning to court all the time. So that's why I say it's not really a legal issue. It's more of a co-parenting and bad parenting, really. Because, whilst you may not like your ex, I'm sure the child who's in hospital wants to see both parents at some point. Unless, of course, we've got safeguarding issues. I know loads of people will jump on and go, what if there's domestic violence? I'm talking in the absence of that. But yeah, it's difficult.
It is. And the court, however many applications we make to the court, Tracy, the court can't order co-parenting, can they?
No, they really can't. I mean, I had a question come in. I don't know what forum it was on. It was a DM on TikTok or Instagram. And it was, I want to go on holiday. My ex says I can go on holiday if he can go on holiday first. And as I'm reading it, I'm just thinking, this is just so petty. There are some adults out there who I think the decision should be given to the children, not the adults, because some of these arguments are just so ridiculous that neither one of them are thinking about the children and are more thinking about one-upmanship. I just need to win this argument or show my ex that I'm in charge or I'm in control. It's just so silly. But yeah, co-parenting, when that breaks down, a lot of times it ends up before the family court. And as you say, Captain, judge can't help with that, because when you both go home, you're expected to co-parent and just get on with it,
I think too many people have children these days and don't think about the consequences of having children and being in a relationship and having to co-parent.
Yeah, I mean, I see it all the time.
I see it all the time.
Yeah, where
those that don't know, I'm a school governor, so that's why I see it all the time.
Exactly. I mean, you're heavily involved in education, but yeah, I see parents, they break up, they separate, and they use the children to weaponize. It's so sad. And there's lots more parental alienation I'm finding. And I've been doing this job an awful long time. It has got worse over the years. I mean, I've been doing it for over 20 years now, and I can see that it has got a lot worse. So many more fathers aren't getting relationships with their children, which is just so sad. So sad. I'm sure he won't mind me sharing his story, but I was walking through London the other evening and I was stopped by a really, he may even be on, a really friendly London cabbie who recognised me and flagged me down. And we had a quick chat for sort of 15, 20 minutes, but it was because he's fighting to see his kids, and I hear it all the time.
There's a common myth around family law that the courts favour the mums.
Yeah, I do videos on this every month. When I'm choosing the titles for my videos, I'm always looking at how many views that they have got. And this one gets, hundreds of thousands of views every time I put it out. And each time I do it, I think, people will get bored of this, but they never do. And that is that the family court favour the mothers. They don't. They are trying to abide by the status quo. The court's very clear on that when parents separate, that's devastating for the children. Devastating, because they love both parents unconditionally. So what the family court is trying to do is keep some sort of normality, some sort of routine. And typically in our society, mothers raise the children. I'm not saying in every household, but in a lot of households, mothers will raise the children. So that's why children are typically left with the mum and have contact with the dad. And as I say, there is exceptions to the rule in every family, I grant you that, but for the majority, and that's where the myth comes from, that, you know, the courts will always side with the mum. They don't. I've done loads of cases where actually we've got full custody for dad. And in fact, we had a caller on earlier today, and he's a dad with a lives with order. So, you know, they don't favour the mum, they favour the children. Sam, let me come to you. Thank you for waiting while we put the worlds to rights. What's your question?
Hi, no worries. Can you hear me?
I can, yeah.
Hiya. So I've been separated for about nearly a year now due to DV and
Yeah.
domestic violence. I fled about a year ago. And obviously during that time, I've just been trying to go to therapy and heal and things like that.
Well done.
And so I'm just like in a phase now where I'm thinking about like going to court, doing the child arrangements and
Yeah.
divorce.
Yeah.
However, what I'm stuck with is like the funds, because right now
Yeah.
I'm just dealing with things by myself financially.
Okay.
So I've just been thinking about like how do people like afford
Yeah.
the costs of going to court? Because obviously we can't go to mediation due to like the coercive
Sure.
control.
Yeah.
And,
So it's a great question, Sam, and it's the reason that the Legal Queen was born. It was to, you know, the social media and the videos I put out there is exactly for this reason. It's to help people who can't afford legal representation and need to do it themselves. So breaking down your scenario, you need to be thinking about 3 applications, all right? You've got your divorce itself. That's application number 1. You then will have your financial application, because that is really important, and that will sever the financial ties that were created when you got married. And then your third application is your child arrangements application, okay? So if we deal with those separately, the divorce you can do yourself. You definitely don't need any legal help with that. It's all done online. If you go to the government website and simply type in divorce petition, it will give you some notes on what to do, and it's all done electronically. Now, there is a court fee, which is just over £600, and I get that that's a lot of money for everyone. So if you are on a low income, or you are maybe in receipt of benefits, before you
I'm
do...
not.
You're not, okay.
No, I've tried to see whether I can get legal aid, but because I own an asset, which is the house that we used to stay in, but he's still living there. But because I fled, I'm not living there anymore. But obviously my name is still on the house, so it's just complicated.
Yeah, I'm not talking about legal aid, Sam. I'm talking about a fee remission. Okay, because if you submit your divorce petition, you're going to have to pay the £600. But the first thing you want to do is fill out an EX160 form. Because if you fill that out and send it to court, they may decide that you don't have to pay that £600. Okay, and then you can continue with your divorce and it hasn't cost you anything except your time. All right, now that's called a fee remission. If you get fee remission for the divorce, then you're also going to get it for your financial application and your children's application. So you won't have to pay court fees. So that's the first tip I would give you. See if you are entitled to fee remission. And as I say, I'm not talking about legal aid at all. And then when it comes to the finances and the children, you're going to do the same thing as you did with your divorce. You are going to make the application yourself. They are all these forms are found on the government website. They are fairly straightforward. A lot of it is admin, name, address, child's name, date of birth, what it is that you're asking the court for, and it might be a lives with order, a contact order or whatever, and you're going to send it into court, okay? And then, of course, you're going to get hearing dates, and then it's up to you how you proceed. You might want to come on the Discord, which lots of people do. I had a few regular callers earlier who came back on and they're like, okay, so we've got the first appointment. What can I expect? What do I need to prepare for? I'm going through the children's, we've got a fact find hearing. What can I expect there? What's a witness statement? So you can use platforms like this. I also do a load of free guides that you can find on my website of exactly how you can do that. There's courses that I've done, so you can buy the course and then you can watch the video,
Okay.
and I'll show you how to do the forms and stuff if you get stuck
Yeah.
there. So don't think that you have to have a solicitor to assist you. Okay, there's lots
Okay.
of
Yeah.
ways you can get to the finish line. I always think when people are embarking on something that's not familiar to them, hence, like the family law processes, think of it one step at a time. That's why I separated those 3 applications out. Just do one application at a time. Okay. And
Okay.
before you know
Yeah.
it, you'll have finished one and you'll get so much confidence out of that. And you'll be like, right, now I can do the second one.
Okay.
All
I
right.
wanted to ask quickly because I've got a meeting in a minute, but I'll join back on after.
Yeah.
So if I wanted to like start a business so that I can help with like funds, if I did want to get a solicitor, am I able to start a business whilst I'm separated? And would that be included in the financial part of
Yeah.
things, like the income from that?
I mean, yes, you can start the business while you're still separated and therefore still married. Any profit that's made from the business, it is a matrimonial asset, but it won't be taken away from you. It will just be included as part of your income. That's all.
Okay.
All right.
All right. Thank you
Lovely.
so much. I really
Pleasure.
appreciate your help.
Okay. Thanks, Sam.
Thank
Bye.
you.
Luby, I'm going to come to you. You are next up. Whenever you're ready. There we go. What's your question, Luby?
Hi, can you hear me okay?
I can, yeah.
Okay, thank you. Sorry, I'm a bit nervous. So I'm 16 months into divorce with my ex, and we originally agreed we'd have our daughter, who's nearly 3 now, 50-50. But over the past 16 months, it's been more like 58-42 on average, because we use a co-parenting app to track it, because he's always messing about with whether he wants her or not, if she's ill and all sorts of other things, if she has appointments and whatnot. So I've decided I just want to try and formalize privately what we've been doing anyway for the last 16 months. And I've asked him about it, but he's refusing. So it's the best thing to try sort of mediation, and then if he doesn't agree, take him to court, to try and get what we're doing anyway made sort of formal and a lot more predictable and everything for our daughter. And what's sort of like the likelihood of that being successful is really my question, I think.
Okay.
Does that make sense?
So when you say 52-48, is it 52% in your favour?
It's actually 58% for me, but yeah, it's in my favour.
Okay. And that's because he just isn't able to have her 50% of the time?
It's not. He could, but anytime she gets ill or has an appointment or basically is any kind of inconvenience to him, he just immediately says, "Well, you should have her then." Like she just had chicken pox a few weeks ago, and his immediate response was, "Well, you should have her," which I don't really kind of agree with, because she was fine in herself. He just didn't want the hassle.
Yeah.
And it messes me about and her about, and everything gets really unpredictable.
I understand. So the reason I asked that is because your question then was mediation or court application. I think mediation, because the court application goes back to, we've had a few questions that have been the same today, but it goes back to us saying, father's only having her 42% of the time. I need him to have her 50% of the time. So we're asking dad to step up and have contact, which essentially is forcing him to have 50%. So the court can't do that.
Okay.
So what I would be suggesting is that mediation.
It was actually a little bit different. Sorry, I was just trying to. Sorry to interrupt you. It was more that actually I'm having a 58%. So why don't we just make that permanent so that it's more predictable?
Oh, I see. But if you're already having her 58% of the time, then there's no need for a court order. Because if 58%
he's basically refusing though to actually do that, but then last minute will just want me to have her. So basically I can the side piece to that is not just that she doesn't know, like last minute, that her dad doesn't want her, and obviously I don't say it like that to her, but I'm constantly having to then say, it's like one day every fortnight or so he'll just be like, last minute, you have her. I just want to formalize it so that I just have her an extra night and just take it all out of the equation. But he's refusing to do that. But then also I can't. I don't know, like, whether I know you don't deal with the child maintenance side of things, but basically he's saying, well, we're 50-50, so you can't claim child maintenance. And actually, it's not 50-50, and it never has been.
Yeah.
So there's that side too, and I'm on benefits, so it does make a big difference to me.
So formalising, if you're looking to formalise something, Luby, then yes, you can't agree that with the other side, then yes, it's going to be a court application. So if that was the initial question, then the answer to that is definitely yes. The other thing I would say is that even though you guys have agreed 50-50, that doesn't always necessarily, and I say this for the benefit of other people, doesn't necessarily mean that no child maintenance is going to be payable. I have lots of clients that have a 50-50 arrangement, but still one of them is paying child maintenance. So I think you might want to just speak to the CMS about that one. But I just throw that in there. But yes, if you're looking to formalise the contact arrangements, but he's not in agreement to it, then that's where the court will help and give you the order. Absolutely.
And they will base that on the fact we've already been doing that anyway. I'm hoping that's kind of my
because that's the routine. Yeah.
Yeah. Okay.
All
Brilliant.
right.
Thank you. Thanks so much for your help.
Absolute pleasure. Thanks. Bye-bye.